The California Supreme Court will decide on a case that could affect the fate of more than 1 million gig workers in the state, perhaps changing the way we hail rides, order takeout, or get groceries delivered. The state's high court will determine whether it should uphold Prop 22, a voter-approved ballot measure sponsored by Uber, Lyft, DoorDash, and Instacart 4 years ago. Prop 22 allows gig companies to continue to treat their ride-hailing drivers and delivery workers as independent contractors. The proposition was the industry's response to AB 5, a state law that codified a state Supreme Court decision requiring the companies to classify those workers as employees. Treating gig workers as independent contractors is central to the business model of the California-based companies. The companies are fighting to hang on to that model, saying it helps them provide gig workers with flexible schedules. But critics say it lets the companies avoid paying employment taxes and shift financial responsibility to their workers and customers, plus governments. The court's 7 justices have 90 days to hand down a decision which could transform the gig economy in California. If Prop 22 is thrown out, gig companies would be subject to Assembly Bill 5. That law, passed in 2019, would throw the companies' business models out of whack. The companies could be required to pay employment taxes for their estimated 1.4 million workers around the state and provide those workers with additional benefits they don't have now, such as sick pay and overtime and occupational accident insurance beyond the $1 million coverage limit under Prop 22. For Cal Matters, I'm Levi Sumagaisai.